Thank you very much, Wes. Hello, everybody. My name is Matthew Erie. I'm an associate professor at the University of Oxford and one of the co-chairs of the American Society of International Law Asia Pacific Interest Group. And we are a diverse group of lawyers, judges, arbitrators, think tank experts, officials, etc., whose work touches on issues of international law in the Asia Pacific region, which we define quite broadly, including not just East Asia, but also South Asia, Central Asia, and the broader Pacific. So we've been running a series of webinars over the past year and a half on topics of international law as they pertain to the region. These webinars feature experts and specialists who share with us their knowledge and their particular insights. The topic for today is the future of human rights for Asia's ethnic and religious minorities. So Asia has become a testing ground for international human rights law. The three major cases that we will examine today are the Rohingya in Myanmar, Kashmiris on the Indo-Pacific border, and the Uyghurs in Xinjiang. Each conflict has its own complicated historical and political background, and yet we can see in each a Muslim minority group at the margins of the nation state, a group that is by most accounts deprived of core human rights. So in 2017, the Myanmar army cracked down on the Rohingya, leading hundreds of thousands to flee to Bangladesh, while those who remained in the Rakhine state are deprived of the right to freedom of expression, association, and peaceful assembly. In 2019, after long-standing conflicts between India and Pakistan over Kashmir, the special status of the territory administered by India was abrogated and a blackout was imposed across the region. Political leaders have been detained, markets closed, and most public services suspended. Next, according to first-hand reports by escapees, since 2017, a significant number of Uyghurs are subjected to extrajudicial detention in China's camps, which include invasive surveillance, forced labor, systematic restriction of their culture, education, right to practice Islam, and forced sterilization and rape. International law has thus far provided limited inroads into these crises. So really the primary question for us today is, can international human rights law protect ethnic and religious minorities such as the Rohingya, Kashmiris, and the Uyghurs? We have a number of exceptional experts today, including international lawyers, activists, and scholars who will provide us with their assessment on these situations. So beginning with Dr. Sharmayi Ghosh, who is an assistant professor at the Azim Premji University in India. She is a lawyer and legal anthropologist who works on issues of rights and justice. She has worked with a number of human rights organizations on their litigation efforts vis-a-vis Kashmir. And next we have Dr. Mohsin Alamput, who is an associate professor and executive director of the Center for Public Interest Law at Jindal Global Law School, also in India. He is an expert in constitutional issues, discrimination, law and religion, law and social movements. Next, we have Dr. Priya Pillai, who is an international lawyer and head of the Asia Justice Coalition Secretariat. She has worked at the International Federation of Red Cross and Red Crescent Societies in Geneva and at the UN International Criminal Tribunal in the former Yugoslavia, and with a number of civil society organizations on pressing human rights issues. Next, we have Mr. Nuri Turkel, who's a Uyghur American lawyer and human rights advocate, born in Kashgar, co-founder and chairman of the board of the Uyghur Human Rights Project, previously the president of the Uyghur American Association, and legal advisor to the World Uyghur Congress. He is senior fellow at the Hudson Institute and commissioner on the US Commission on International Religious Freedom. And we may be joined by two additional experts. We're waiting for them to join us. If they do, I will give a quick introduction to them. So what we're going to do is we're going to have a number of presentations. We'll begin with Kashmir. Sharmayi, we'll start with you. And if you don't mind, please begin with the kind of historical, legal, and cartographic dimensions of the current conflict there. I turn it over to you. Thank you.
Thank you, Matthew. So I'm just going to share my screen. So just give me a second to get that set up. Okay. Uh, can you see the presentation slide? Okay, great. Thanks a lot, Matthew, and it's really an honor and privilege to be here without much sort of preliminaries because we're already running late. I'm going to jump right into it. Like oppressed peoples everywhere, the Kashmiris have a pretty dark sense of humor, and there's this joke that they like to say about Kashmir and how India talks about Kashmir. So when they say that when India is before the UN or a multilateral forum, it claims that Kashmir is a bilateral dispute with Pakistan, and so they will only talk to the Pakistanis. When it's in talks with Pakistan, it claims that it's an internal matter and they will only talk to the Kashmiris. And when it's talking to the Indians or to Kashmiris, it claims that it's not a dispute at all. So while that might be funny, the shifting registers of internationalism, bilateralism, and national sovereignty, actually that this joke gestures towards, obscures the kind of the grave, widespread, very well documented and systematic human rights violations and attacks on the civilian population that are taking place in the context of an armed conflict and disputed territory in Kashmir. So if there's one point I want to make in today's presentation, it's this, that it's absolutely imperative for the recognition of the international character of the Kashmir dispute and the centrality of the Jammu and Kashmiri peoples, and I mean all the peoples of Jammu and Kashmir, and we'll get to that in a moment, in the disputed territory, are central to peace and security in the region and sort of the resolution of the dispute itself. Actually, there are, if you look at the cartography of the dispute, there are three centers or three theaters of conflict that are ongoing in the historical entity of Jammu and Kashmir. That's the princely state that was cobbled together by the British from several distinct sovereignties that were handed over to the Dogra rulers in 1846 through the Treaty of Amritsar. And it's divided between three national jurisdictions and 5 or 6 sort of administrative units. There's the border conflict between India and Pakistan, the 740-kilometer long disputed border. There's a UN ceasefire line, which is now referred to as the line of control, a highly militarized, constant skirmishing. The UN, there's a UN monitoring group, but India does not allow the UN access to its side of the border. Minefields, 3 tiers, as I said, of electrified fencing, people's communities living amidst these tiers, so in the no man's land, who don't have access to their fields, for example, or are locked up within the fencing at night. There have been 4,000 reported ceasefire violations in the last year, and civilian killings are pretty routine on both sides. So that's conflict number 1. There's the counterinsurgency war in the hinterlands of Jammu and Kashmir, primarily concentrated in sort of this area, the Kashmir Valley, or sort of this area, which is divided between India and Pakistan, but huge occupations of land, permanent military settlements all across Jammu and Kashmir, massive military deployment that makes it the most militarized zone in the world, with an estimated 1 soldier for every 17 civilians. Counterinsurgency operations and sort of counterinsurgency warfare techniques, area domination, cordon and search, so sort of cordoning off villages, house-to-house searching, body searches, and of course, widespread impunity, martial law jurisdiction, and sort of legalized impunity through special security laws and and sort of martial laws. And then there's the Indo-China dispute in the Ladakh region, which has recently flared up, which we will not talk so much about. Now, one of the sort of common ways in which the conflict is described is as a Muslim, is a conflict between a Muslim separatist movement within a broadly secular Indian polity, and which is now under Hindu majoritarian government. But it really doesn't take into account the multiracial, multi-ethnic, and multi-religious character of the peoples of Jammu and Kashmir. The Islamic nationalist character of the self-determination movement is sort of subsumed within a global war on terror kind of language. Pakistan is blamed, where the indigenous sort of moves towards self-determination are largely sort of bypassed. And other histories of resistance to Indian control, for example, other instances of secular self-determination groups are usually erased, and Muslims, of course, as Matthew mentioned, are the most violently targeted, both in the counterinsurgency war and in the general kind of militarization. The histories of the minorities within, so the Muslims of Jammu, the Hindu majority region, the Muslims of Kargil, which is the Buddhist, well, not majority, but is kind of often in the Indian policy seen as the Buddhist region, invisibilized, while it's seen as a Muslim militancy problem. And the Kashmiri Pandit, that is the Kashmiri Hindu forced displacement that took place because of violent attacks in the 1990s, are sort of weaponized in some ways by the Indian state, though there has been complete impunity for the perpetrators, both of those attacks and widespread and systematic attacks against Muslims. The return of the Pandits and settlement of Pandits is sort of located now within this Hindu majoritarian supremacist kind of discourse of a mythological sacred claim to this Hindu geography. Also, what has happened because of this trifurcation, where the Kashmir Valley is seen as an exclusively Muslim area and an insurgent area, terrorist sort of hotbed, Jammu is seen as a Hindu area, and Ladakh is seen as a Buddhist area, is that in the counterinsurgency, these fault lines are constantly deployed against each other. I'm really sorry about that. So these fault lines are constantly deployed and played out against each other. For example, arming certain civilian groups against others in counterinsurgency and paramilitary operations. So just to give you a very broad brushstrokes history of the conflict, and I'm not going to go into details about this at all, but I have written about it. So the first phase, in the earliest phase of the conflict, I mean, I also want to kind of highlight that these phases are not strictly... Sheru, relax, sit down, Baba. I'm really sorry. So this is just a heuristic sort of thing, in the sense that the international, obviously the strands continue to coexist and overlap. So it's while we are now currently in the fifth phase, there's a current ceasefire on, and the military patrols in the civilian areas are flying white flags. So you know, it's not as if the international dimensions have been completely subsumed, but it's just to give you a broad kind of brushstrokes idea of the history of the dominant strands of state policy that have dominated. So it's, as you know, one of the oldest sort of peacekeeping referrals to the United Nations Security Council under Chapter 6. A plebiscite mechanism was set up. The UN Commission on India and Pakistan was set up, and which looked at the dispute largely bilaterally. Then there was the second phase, where India sort of asserted a constitutional claim over the entirety of Jammu and Kashmir through constitutional mechanisms that were set up under the Indian Constitution, which said that it was the legitimate sort of democratically elected government for the entirety of the region, including the region under Pakistan, actual Pakistan control. And then we go on to the third. Shall you please relax, baby? I'm not going to open the door. Just sit down. I'm really sorry. Then there's the third phase, which is the armed insurgency, which is when the greatest number of human rights violations took place. And we we move on to sort of the fifth phase, which has been inaugurated by the constitutional abrogation of the special autonomy provisions that gave Kashmir special jurisdiction. And there have been widespread changes in land ownership laws, in zoning laws, in laws related to permanent residency, which would allow settlement and ownership of outsiders, non-Kashmiris. And it also affects, since the state subject, which is the permanent residency qualification, it applies to across the zone. So it applies even in the Pakistan-controlled territories. It actually sort of affects the international character of the dispute itself. So I'm just summarizing. There's been systematic and widespread human rights violations that are taking place. They've taken place in the context of an armed conflict and an exceptional jurisdiction. We can go into details of what the nature of that jurisdiction is, whether it's a military occupation or what it is. The Indian legal regime has sort of been used to grant impunity for almost absolute powers of executive discretion and military authority in Kashmir. The dominant view of Kashmir as a constitutional dispute domesticates it and obscures questions of use of force, aggression, the status of non-state actors.
Sorry, if you could please wrap up.
Yeah, that's it. So that's basically it. The importance of seeing it as an armed conflict, and that's basically what I wanted to say. Thank you, and I'm really sorry for the interruptions. The doorbell kept going, and yeah.
That's terrific. Thank you very much for that overview, Sharmila. It's extremely helpful and indeed comprehensive given the time constraints. So thank you very much for that. So now I'd like to ask Mohsin to please explain to us how different groups and actors are using different types of human rights discourses as it pertains to the crisis. So Mohsin, over to you, please.
Thank you so much, Matt, and to all the other colleagues and co-panelists. It's quite an honor to be with everybody here. I've learned from their work, and also quite wonderful to follow Sharmila, because I've learned a lot from her work as well. So maybe what I'll do is broadly stick to my notes in the interest of time, with the aim of basically picking up some of the strands that Sharmila mentioned already, and specifically to offer some sort of thoughts on the future pathways in relation to international law when it comes to Kashmir. It'll be speculative, but it is really in the interest of some conversation subsequently. So my aim will not really be to engage much in legal analysis. Rather, it will only be to flag some key political variables from a law and politics perspective that we may want to keep our eyes on. Now, in order to do this, I think we'll need to appreciate three elements. The first is the way the Kashmir issue has been legally framed, often in overlapping ways and in competing ways by various actors. Sharmila mentioned most of the aspects related to that. The second is the various state strategies of obscuring the nature of violence, particularly those adopted by the Indian state. And in my view, an extremely important third avenue, which is the evolving discourse of resistance, especially among Kashmiris. So some preliminary assessment of these elements, even if superficial at this stage, would be quite helpful. So let me first start with the political strategies of obscuring, or one might even say invisibilizing, the violence in Kashmir and broadly in Jammu Kashmir. And I would just underline 4 strategies, some of which have already been pointed out, but I just wanted to emphasize them very quickly. The first strategy is what I may call insidious legality. So since 1948, as Srimoy said, the Indian state has adopted these discrete administrative and bureaucratic criminal legal forms to establish a disciplinary and penal regime. This is, to quote what a legal scholar Tarnab Khaitan recently described, the Indian government's attitude towards democratic institutions. It's killing with 1,000 cuts. Much of this is, as the word insidious would suggest, subtle, diverse, and hidden. For instance, while Article 370 on the face of it is meant to guarantee some regional autonomy, it was the very basis in which an insidious capture of the state happened, undermining federalism and democracy through exceptionalist rule. The second strategy is that of isolation. So isolating Kashmir from the other regions in J&K, and isolating J&K and its claims of regional autonomy from other similar claims of provincial federalism in India. The third is exceptionalism. Again, Srimoy and many other scholars she has worked with have aptly described this as the assertion of what they call permanent danger. Permanent danger legitimates perpetual emergency laws, impunity legislation, preventive detention. The flip side of this, as I surmise, is the liminality of Kashmir. So the Indian state has asserted that regions like Kashmir and perhaps other regions as well, particularly in India's northeast, provisionally need emergency laws, but these areas, they claim, are on their way to normalcy. The state has had to constantly claim this, that these regions are at the very cusp of normalcy through elections, development, integration, whenever it seeks to assert permanent danger. And then is what I believe is, I guess, a subtle but an equally important strategy to extend Jasbir Puar's terminology, let me call it democracy washing. We have heard this before. It goes something like, we are the only democracy in this part of the world, hence we deserve a higher status. In the various rounds of the Universal Periodic Review, for instance, the Indian state often asserted that there is a vibrant democratic debate in India about the revocation of the Special Powers Act, which is an impunity law in Kashmir, and hence India deserves global deference. Now, each of these strategies, I believe, are under tremendous stress today. The ideological compulsions, or at any rate, the political compulsions of the present regime makes subtlety unviable. The government needs to be seen doing things. The dramatic way in which it abrogated 370 is but one instance. It will continue emphatically denying official accountability rather than pushing things under the carpet. Claims of impending normalcy, I believe, are also both unviable and perhaps more importantly, far less of a political incentive for this regime. Visible permanent danger now is the very basis of political relevance and political power. The political isolation of Kashmir is complete, especially if we look at the so-called mainstream electoral politicians in the valley, I mean, within India. But the road ahead for this is unclear. This isolation has broken down real or imagined bridges between Delhi and Kashmir, which were central to the legitimation of political power and political control. Most dramatically, claims of democracy increasingly sound hollow now. Ironically, there has been a Kashmirization of Indian civil society. The report on free speech and press, free and fair elections, dissent and protest, well-being of political opposition, a healthy, liberal, tolerant environment is dismal at best. I propose that we need to keep an eye on how this weakening, or perhaps the complete dissolution of these strategies of legitimation, will impact a numerous set of things, including greater international focus, calls for international political accountability, visibility of the issue in international human rights forums. Equally important is how the international law framing of Kashmir has evolved, and Srimoy has already discussed this. I'll sort of reframe this issue of evolution slightly for the purposes of my argument. The first phase of international law framing was grounded, I believe, in claims of self-determination and imperatives of security. This was a moment of Security Council resolutions, for instance. This phase gave way to bilateralism starting in the 1970s, personified in the Shimla Agreement or more recent, the Agra Declaration. In some ways, at least at a discursive level, these two phases live on, overlapping but with conflicting interpretations. India and Pakistan disagree about whether the first phase of UN norms is still applicable. They also appear to disagree about the substantive boundaries of bilateralism. At any rate, the Indian position that Kashmir is purely an internal matter is inaccurate at best and disingenuous at worst. Neither of these two framings hold much political promise, unfortunately, at the moment. Despite the reconfigurations in global power, or perhaps because of that, the Security Council is and will remain a bystander. The same goes for bilateralism. Bilateralism has, I believe, undermined the political agency of Jammu and Kashmir because it removed them from the table. It also made the issue contingent on the complex and fluid geopolitical and domestic calculations of India and Pakistan. J&K, in a way, remains trapped in the futures it cannot influence in any meaningful fashion. Where I see hope, finally, is the evolving human rights frame and the powerful contribution of the language of resistance. The human tragedy in Kashmir is a product of complete breakdown of decency and norms of the rule of law. But the people of Kashmir, in response, have sought to retain their humanity and agency, often by performing acts of resistance through storytelling and memory making. Two forms of resistance have always struck me. The first is the act of documentation. Kashmir's journalists, human rights defenders, academics, despite tremendous odds, have built a repertoire of loss and suffering. This has not been an easy task. They have been subjected to detention, violence, censorship, death. The second is the aesthetics of storytelling. Just as the state's rule of law has floundered, the people of Kashmir have constructed mimetic forms of law. The most powerful examples of this are the various people's tribunals that document the lives of people as much as they offer us an alternative to what a desirable law may look like. Resistance as storytelling and legal mimetics, I believe, has constituted the third most recent international law framing, that of human rights. The two recent reports of the Special Rapporteur testify to how discourses of resistance create international law, how they are juris generative. India and Pakistan refused to grant admission to UN officials, but these reports relied on the narratives of Kashmiris to offer an impressive human rights law framing of Kashmir. To conclude very quickly, I see two interesting avenues of how this framing may evolve over time. The Special Rapporteur of Minority Rights has already taken cognizance of the Kashmir issue. Most recently, he, among others, issued a statement expressing concern over the abrogation of 370 and the regional autonomy of Jammu and Kashmir. We'll have to wait and see how productive this framing of looking at Kashmir as a territorial minority issue is. I would also keep an eye on the most fascinating assertions within the new generation of Kashmiri resistance, among them, many of our panelists, to frame the Kashmir issue as that of occupation. This framing needs a reconceptualization of international humanitarian law of occupation. It also needs a stronger restatement of Kashmir's history, but only time will tell how far these evocations will be politically salient. I'll stop here. Thank you.
Thank you very much, Mohsin, for what I think is a brilliant analysis, particularly along the lines of how the state of India is engaging with the international human rights regime, and then how Kashmiris are producing their own kind of counter narrative. Truly fascinating. And now I'd like to switch to the case of Xinjiang and ask Mr. Nuri Turkel to please update us on what is happening there and explain the inroads that international human rights law has made to date in that conflict. Mr. Turkel, over to you, please.
Thank you very much. I'd like to begin by thanking Professor Ari for inviting me to participate in this discussion. I have to apologize in advance that I have to leave right after my presentation to participate in another meeting. As you have been reading in the news, the Uyghur genocide grabbing headline and resulting in various policy responses here in the United States and Europe. The way that this started initially was China denying the existence of even the industrial scale concentration camps that they set up. Based on various reports, relied on the open source information that the Chinese published, there are anywhere between 1,200 to 1,300 industrial scale concentration camps set up starting late 2016 all the way to present time. There's a future story recently published in New Yorker magazine. It takes about 2 hours to listen to it. That particular future story describes the way that the Chinese authorities paved the way to set up this modern day concentration camps and engaging in technology supported genocidal actions against the Uyghurs and other Turkic Muslims. How did we get here? Starting 2013, after Xi Jinping becomes the supreme leader for the PRC, he engaged with his own advisors, academics, to formulate tough policy, to root out anything that may become a potentially a threat or causes could be a reason for instability within PRC. So to the Chinese authorities, Xi Jinping and the Communist Party, stability is a paramount concern. That stability involves China's engagement with the rest of the world, involving regional issues, economic issues, national security issues. And then domestically, instability would cause a challenge or pose challenges to the leadership, Xi Jinping himself, and the CCP's continued ruling of China. When you look at the reasons that the Chinese states and as well as some analysts in the academia and think tank and media oftentimes cites or refers to China's security concern, citing several incidents took place during the period of 2012-2015. But that kind of social resentment, even a violent nature, happens all over the China all the time. But the Chinese never call those as acts of terrorism. And also with the events that the Chinese often cite has never been officially, formally, independently verified. So basically the international community echoing the propaganda coming out of Beijing, even some instance almost sounded affirm that somebody has validated those claims. Nonetheless, the Chinese have been doing three things. One, brought back the old memories, days of Holocaust like repression. They brought back modern slavery. They brought back a sexual violence against Uyghur women through various forms of violence committed against the female detainees in the concentration camps. Recently, BBC, CNN profiled some of the camp survivors' grotesque experiences in the camps. Based on China's own admission through publicly available information, they have effectively diverted Uyghur population growth by over 80% during the period of 2015 through 2019. And then just in 2020 alone, they prevented Uyghur population growth by 24%. So that is also in the minds of the policymakers here in Washington and Europe in particular. And also domestically, they are creating a open prison-like environment for those who are not in the camps, prison camp, concentration camps, or the forced labor camps. Through this pervasive technology, surveillance techniques that they have tested in inland China previously, utilized on the Uyghur people, and now exporting these methods to over 80 countries based on the hearing that my commission organized last year. One of the China experts who teaches at one of the reputable universities in the United States, who follow specifically on surveillance, Chinese surveillance techniques, told us that 83 countries, this was about a year ago, already in the process of adopting, importing, adopting, and utilizing the Chinese surveillance technology. This spread, the Chinese technology oriented repression policy, surveillance policy techniques is metastasizing. This will be a threat to civil liberty, international norms, human rights, privacy, political freedom, democratic system. Eventually, this will be a much bigger problem that the international community eventually will end up dealing with. And then finally, they are also doing something quite remarkable, that they're using their economic interest, regional influence, to silence, buy out silence from the international community. As we speak, there's no a country except for Turkey have publicly condemned the Chinese, the ongoing genocidal actions against Uyghur people. The statement coming from Turkey was not from Ankara, it was from the UN ambassador, the Turkish ambassador to UN, who joined the effort by the United States, Canada, UK, just about 2 weeks ago. So that's pretty much it. So it's happening on the domestic front, globally, and also the same methods have been exported. In late 2018, state-run media publicly bragged about the effectiveness of China's Muslim repression, or dealing with so-called world's Muslim problem, explicitly and in a mockery fashion suggested that while the United States and its Western allies bombing Muslim cities, killing Muslim people, the Chinese are helping to build roads, schools, and helping them to have a better life. Therefore, the Chinese method of dealing with the world's so-called Muslim problem should be something that could be utilized elsewhere. In the face of these atrocities, what has been the international response? Except for the United States and several other liberal democracies, the rest of the world is still sleeping at switch. The responses have been tepid and meandering, despite the severity and scope of the atrocities that has entered its fourth year as we speak. The international community still trying to figure out how to overcome China's bullying. Case in point, Australia, with a sizable Uyghur population, could not publicly condemn or join the effort to give a proper name to the atrocities. Germany also has a large Uyghur population, has not said anything publicly yet, especially on the chancellor's level, but they have been engaging in various forms. But the United States has been most vocal. Starting October 2019, United States take the case to the UN by using the annual gathering at the United Nations, the UNGA, to organize several side events to encourage our partners and allies to join the effort. And Secretary Pompeo then even went to Central Asia to meet with the Central Asian country counterparts, and also met with the victims. Starting October 2019, the United States has announced 74 punitive sanctions against the Chinese officials. That includes sanctioning of the entire police department, including the one police entity that the movie Mulan credited. And also that includes something called Xinjiang Production Construction Corp. XPCC is the acronym. That has believed to have 800,000 shell companies around the world. that is also sanctioned. And there are a number of visa restrictions, individual sanctions against the Chinese officials under the Global Magnitsky Act has also been utilized. What has not been utilized is the international courts, Court of Justice. China has been, as you know, has been a big obstacle on the accountability concerns or efforts. The United Nations to this day, except for this third panel, Committee on Elimination of Racial Discrimination, that made a statement in November 2018, the rest of the UN body still on mute. Particularly Secretary General Guterres has not said anything yet because of apparently, if I may borrow Kenneth Ross, the Human Rights Watch president's recent statement. So apparently UN Secretary General is serving the interest of the PRC instead of the member states. There an effort to address this through People's Tribunal, which will convene in the UK on June 4th. There's also have expanded attempts to continue targeted sanctions against the Chinese officials and entities through Secretary Blinken's engagement with the partners and allies in March of this year. There were additional coordinated sanctions were announced by the United States government and Europe. So these kind of targeted sanctions, naming shaming is underway. President Biden said it very clearly that this is a value based concern. Some people initially tried to spin this, suggesting that the Trump administration was using this for geopolitical purposes. But don't forget, even without the Uyghur genocide, the U.S.-China competition that has been articulated by Kurt Campbell just a few days ago in his speech, that the era of engagement with China is coming to an end. So this has nothing to do directly with the Chinese atrocities against the Uyghurs. If you look at the China's intention to challenge the United States or change the international rules-based system, started way back in 2013 with the publishing, with now the public document known as number 9 document that is publicly available. So this is about China's ambition to take over, and using the very influence, economic power that the Western societies, governments help them to build through the encouragement and helping China to become a WTO member. So there was a broader awakening, realization that there's a serious, real geopolitical, economic, strategic, and also moral reasons for the United States to take a tougher stance. As you may have noticed, just yesterday, President Biden asked China, intelligence community to investigate the source of Wuhan virus in the next 90 days. So this is ongoing effort. So please be mindful that the China, as a signatory to a number of conventions, treaties, have been violating their own treaty obligation. China is also a signatory to Genocide Convention. They're not only violating, but they're also making attempt through their economic and diplomatic influence to make the countries to even admit, normalize genocidal actions. They're also using the people on the ground in China to make them to phrase the genocidal policies. On the economic issues, even without the Uyghur crisis, the United States and West must be on the wake up. One must be receiving a wake up call to respond to the China's polluting of the global economic system. More than 80 global brands believed to use forced labor, including the solar panels sold in the United States. Any of the big brands that you use or know believed to use Uyghur forced labor. That includes Coca-Cola, Nike, Volkswagen, Heinz ketchup, Campbell soup, Adidas. So the problem is much bigger than what you've been realizing or reading. So I will conclude by saying that this is the ongoing genocidal actions against the Uyghur people is no longer a simple human rights concern. That is an active technology-supported genocidal campaign. If the United States and its allies, its partners, including those people and government officials who care about the future, need to address this. This is becoming a global issue. This is becoming a serious moral issue. This is becoming a serious strategic issue. And importantly, this is the Chinese actions domestically, globally, is creating a huge problem for the international law, international rules-based system.
Okay, Mr. Turkel, thank you very much for your sobering assessment of the current situation in Xinjiang. It's a striking example of the limits of the contemporary international human rights regime. We thank you for your insights and your experiences, and thank you again for joining us and fitting us into your schedule.
Thank you. Thank you very much for having me.
Okay, at this point in time, unless Mr. Ben Emerson has joined us. Ben, are you online? No, okay. So we will now shift from Xinjiang to Myanmar/Burma. And I'd like to take a moment to introduce our second speaker for this case discussion, Ms. YY New. So Ms. New is a former political prisoner and founder and executive director of the Women Peace Network in Myanmar. She spent several years as a political prisoner in Burma. Since her release from prison in 2012, she has dedicated herself to democracy and human rights in the country and the broader region. So now, without further ado, I'd like to turn it over to Ms. New, who will give us a kind of update on current developments in the country and the role of civil society to promote international human rights there. So Ms. New, over to you. Thank you.
Thank you very much, Matthew. It's been very enlightening to hear previous speakers on Xinjiang case and Kashmir case. So as I was asked to provide recent development in Myanmar and the role of civil society in promoting international human rights law or protections of Rohingya specifically, I'm going to be very, we don't have a lot to talk about this in terms of the civil society's role when it's come to Rohingya, but I will try to expand as much as I can, as you know, as far as I've been working on this issue for a while and knowing the civil society movement in Myanmar quite well. Before talking about that, just to update what is happening in Myanmar. As you know, we have the military coup on February 1st. This year, it's been almost 4 months now, and everything has shifted. Everything has changed, and things has dramatically shifted. Like public perceptions on the Rohingya or public view on the military, or everything has dramatically changed. Since the military coup, right now, the military has killed over 800 people and detained over 4,000 people. And many of them have been many of them whereabouts have been unknown, those who are detained, and most of them are not getting right to free trial. So that's the situations of detainees has been very, very concerning. And on top of that, we've been seeing increase in killing of detainees during the detention. Only this week, in this week, we have two detainees who were detained, and then the next day or in 2 days, their dead bodies has been returned to their family members. So this kind of cases has been increasing, and it seems like military feel very encouraged or like emboldened to really, commit this kind of heinous crimes, with total impunity and without any fear. So it's become a kind of culture. So the aggressiveness of the military has been quite shocking. And I would say this behavior of the military continuing due to the impunity that the military have enjoyed over the past decade, on the case of Rohingya or on other gross human rights violations that they have been they committed against other ethnic communities in the past. When it's come to public opinions on the Rohingya, I'm sure many of you have seen and noticed that I would say this time this period is when we have the most empathy from the public on Rohingya issue. When I say public, like really like people from the grassroots level, ordinary people, protesters are showing their empathies and their understanding, showing their empathies on the suffering of the Rohingya and apologizing Rohingya. And it's been very organic, and it's happening on the social media as well as on the ground. So that has been very, very encouraging. And also like student unions and some civil society organizations have been actively promoting the cause of Rohingya these days. And pushing the national unity government, which is a government founded after the military coup by the elected officials. Now civil society organizations are pushing the NUG to have a clear positions on the Rohingya. So that's been all of this has been a great news, and we have never had this kind of experience in the past, I would say. Like when the violence started in Rakhine State in 2012, when the hate speech was so big on social media, we have no friends in Myanmar. We had no civil society organizations or groups that understood Rohingya or stood up for the Rohingya in those days. Was extremely isolating, and it was extremely hard to even approach and talk about the Rohingya. However, so my organization, Women's Peace Network, is the first Rohingya civil society organizations in Myanmar. We work on youth development, basically promoting youth leaderships and civic educations by providing trainings for the young people in Myanmar, especially the university students. So a lot of the students from the different universities, student unions are actually our alumni. So we work with young people. That was one of the major entry for us to be able to have broader connections and I guess the relationship with the broader younger generations in Myanmar. We didn't actually train anything about Rohingya, but we provide trainings on the values and principles, democratic values and principles, human rights, and so on. So that was one way of our indirect approach to build the public awareness and to promote democratic culture among the young people. And we have also been working on building allies and coalitions, identifying like-minded civil society actors and the organizations. And we try to work with them to raise their knowledge on the Rohingya, as well as to come up to provide them ownership of their case. Because when the violence broke out in until 2013, 14, 15, many civil society organizations in Myanmar think the Rohingya issue is a separate issue. It's an outsider's issue. It's not the issue that their issue or the country's issue itself. So they, through our engagement with the civil society leaders, academics, as well as journalists, like key stakeholders, we try to make them understand that this is not a separate issue. This is the issue of our country, and we have to work together, and you need to get involved, and you need to take leadership step into this case, and that's the only way we will be able to address. So that was another attempt that we have made over the past 5-6 years, since 2015 to till now. And today, many of these organizations are really taking leaderships to change in public opinion, but also changing, influencing the policies of the leaderships, including the national unity government. So that's the second, I guess, strategy that we have used as Women's Peace Network. And at the same time, we have been doing using all these international tools and mechanisms available to promote or protect the Rohingyas' rights by doing advocacy, conducting advocacy domestically inside Myanmar, as well as internationally at the UN and with others. Especially, we engage with almost all UN mechanisms, from the special procedures to the General Assembly, to everything that available. And there are a few civil society organizations that work with us, that has been working with us. So at least I think one of the strongest one is this Progressive Voice. So in their advocacy work, they have always included the Rohingya issue, and we work together with them for many years until now. So otherwise, there weren't many strong civil society organizations with the focus of Rohingya, or basically integrating Rohingya work into their work. There was very limited, very few organizations have done that. So, but 10 years ago, nobody knew Rohingya. So, it's a great progress, I must say that. However, I would say, some of us, a few people or groups, we've tried very hard to raise awareness domestically as well as internationally, in particularly using not just public awareness, but using the tools, the advocacy tools, international laws, with the UN, mainly with the UN mechanisms or agencies. So that was quite incredible, though, and I'm really hoping that with this change in Myanmar, the unity government, or the national unity government, NUG, the current civilian government, they would actually use this tools and this international laws, not only to promote, not only to acknowledge Rohingyas genocide, and to or not only to work on the protections of Rohingya rights in the future, but also use strategically to really protect rights of everybody, and to hold the military leaders accountable. So yeah, I think right now I'm feeling very hopeful positive. And I hope that we will be able to strengthen our advocacy and continue to work on justice and accountability for the survivors and victims.
Thank you very much, YY. Very helpful to understand the issues from an activist perspective, and really fascinating that although recent events have worsened the situation in some ways, they've also increased awareness and fomented coalition building. So very interesting, and also thank you for your optimism on these points. Now I'd like to turn to Dr. Pillai, who I've previously introduced, who will talk to some more of the legal aspects, and in particular, the recent cases as applied to the Rohingya. Dr. Pillai, over to you, please.
Thank you very much. Firstly, just thank you for having me on this panel. It's a real privilege. And I think in particular to follow YY Nu, who is really a leading voice among the Rohingya community and has advocated on these issues for years and years. So, we really have a lot to learn from her. So I'm really happy to be following her on this panel. I'll keep my remarks fairly focused on the legal developments, and I know we're a bit short on time, so I'll try to be as fast as I can. Just very quickly, an overview in terms of the international legal arena. You've got 4 legal fora apart from the UN and the Human Rights Council that are essentially activated now around around the crimes related to the Rohingya. 2 international courts, 1 domestic court in Argentina, and 1 international mechanism. Let's start with, it's the ICC, which is individual criminal responsibility. We look at the International Court of Justice, which is state responsibility. We're looking at universal jurisdiction in a domestic court in Argentina. And last but not the least, the independent investigative mechanism for Myanmar, which is a sort of sui generis mechanism, which has 1 precedent before it. And we'll go into some of the details. Very quickly, I think first on the International Criminal Court, this is a situation with the People's Republic of Bangladesh and the Republic of Myanmar. Keep in mind, this was initiated by the prosecutor in 2018. It's a very unusual case because it was the first case that involves a non-party to the Rome Statute, Myanmar, and Bangladesh, which is a state party to the statute. So straight off the bat, there were a lot of legal questions around this case. The prosecutor actually approached a pretrial chamber and said, look, on jurisdiction, is this something that we can do? Is this something that we can go ahead with? A pretrial chamber said, yes, proceed. There are jurisdictional boundaries, which is that, you must focus on the fact that there is a cross-border component, essentially saying if there are crimes that have been committed in Bangladesh, which then continue over the border, Myanmar, which continue into the border in Bangladesh, then the court has jurisdiction and the prosecutor can go ahead. Now, after this, there was a next hurdle, another stage. And keep in mind that there are different stages at the International Criminal Court. One is, an initial examination. The next is the sort of very formal investigative stage, which the prosecutor needs to get authorization from the judges, from a pretrial chamber. November 2019, this is one very interesting week where a lot of legal developments took place linked to the Rohingya. November 2019, the pretrial chamber actually said, yes, you can go ahead, authorize the prosecutor to move forward on the case. So it's a big step. It's also happened quite fast compared to a lot of the other Asia-based cases at the court. So I think something to keep in mind. It's a limited scope under Article 7 of the Rome Statute, which is essentially deportation, other inhuman acts, persecution, crimes against humanity. But I would say looking at the decision of the chamber, there is a certain amount of discretion that has been left to the prosecutor. Look at paragraph 74. It's now for the prosecutor, for her to determine what are the elements of the case she wants to focus on and what the scope is, how far she's going to test the boundaries based on the jurisdiction. So leaving aside the ICC, and again, keep in mind, it's focused on the individual. It's individual criminal responsibility. Let's pivot now to the International Court of Justice. Now, the ICJ, the Gambia filed an application at the ICJ also in that same week, November 2019. The legal basis for this is the Genocide Convention. Now, questions were asked, how come the Gambia? Why the Gambia? Why not another state? Does it have the locus standi in a way to file this application? As part of its application, it also asked for what are called provisional measures, which is sort of an interim measure of protection. And this was seen as urgent. The court moved quite fast. And in December of 2019, held hearings in The Hague on these interim measures to determine whether it should issue these protective measures or not. Of course, a bit of a lightning rod, because these were the hearings at which the state councillor Aung San Suu Kyi, went to The Hague and represented Myanmar before the ICJ and argued before the ICJ on behalf of Myanmar. So it was quite a dramatic moment as well. Within a few weeks, the 23rd of January last year, the court issued its decision. Keep in mind, at this stage, the court has the ability, parties have the ability to ask for an ad hoc judge. In this case, all the judges, including the ad hoc judge from Myanmar, issued a unanimous decision saying we need to issue provisional measures. Now, the provisional measures in this case are quite unusual. There were a range of 6 basically orders that the ICJ has issued to Myanmar. One of them was to preserve and ensure that the evidence of crimes under the Genocide Convention were preserved by the state. Again, there are questions of implementation, but I think hugely symbolic as well. And the second point that I'd like to make is that under this order, the court took a proactive role. It basically said within 4 months of this order, Myanmar is to submit an implementation report on what it's doing linked to this order, and then every 6 months thereafter. So in fact, we've just come to the 4th report anniversary 2 days ago, and there's increasing sort of discussion around the fact that perhaps these reports now need to be made public, especially in light of what's happened since the 1st of February. Keep in mind, a sort of little known, or sort of something that went a bit under the radar, but in December, the ICJ also changed its rules. And one of its rules, Rule 11, a small tweak, was basically to set up a committee that could look at the implementation of provisional measures. So this has direct relevance to the Myanmar case as well, and might serve as some impetus for greater enforcement or greater implementation. The one other point on the ICJ case is the fact that other states have intervened. So you have Maldives, you have Canada, and you have the Netherlands that have basically said they are going to intervene legally in the case as well and join the case as parties. So again, there'll be many sort of many twists and turns. There are still a lot of stages to go in this case, but it's already been one of the cases that has drawn on a lot of innovative legal argumentation, and we really have to see now how far that the case goes. The next is the independent investigative mechanism for Myanmar. As I said, a sui generis mechanism. It has a precedent in the Syria mechanism. So in 2018, the Human Rights Council basically said, yes, this is something that needs to be set up. Keep in mind, it really has relevance, especially today, because the mandate for this mechanism is that it is able to analyze, collect evidence of serious international crimes in the territory of Myanmar from 2011. So essentially, it is, and it can collect evidence also of what's going on right now with the military coup. In fact, the IIMM has actually issued a call saying if you have evidence, if you have information on atrocities and potential crimes against humanity in the territory of Myanmar, not just linked to the Rohingya, please submit it to the mechanism. And this will basically be a case preparation. It's not a court. It's a mechanism that will prepare cases for other proceedings, whether they're national, international, regional. The forum is not determined as of now. And the last point that I'll bring up is the universal jurisdiction case. This is a case that one of our Rohingya colleagues who runs and has founded the Burmese Rohingya organization, UK, has initiated with a former UN Special Rapporteur on Myanmar, Thomas Quintana, who is his counsel in Argentina. They've basically asked the Argentine courts, under the principle of universal jurisdiction, which is essentially domestic prosecutions of international crimes wherever they occur, with some limitations, to take on investigations and to take on a case linked to the Myanmar military as well as Aung San Suu Kyi. Now, Argentina has a history of this. They are actually already investigating crimes related to Spain and Franco. And in fact, some of the questions around this case are with the prosecutor who's in charge of that case as well. As of now, the case was rejected in the first instance, but on appeal, it's now proceeding forward. the prosecutor has asked the International Criminal Court to give her the green light, basically, to say that there's not an overlap, a substantial overlap. And that, I believe, has happened, but they're still waiting for a few more stages before there's formal acknowledgement that this can move forward. So I think I'll just stop with that, just to say that there are different legal proceedings. There's a certain amount of confusion also, and there's a certain amount of overlap to an extent. Again, I think there are a lot of legal strands that we need to pull out, and that's something that has been the subject of a lot of discussion and debate as well. But again, also very hopeful. Thank you.
Thank you so much, Dr. Pillai, for that really diagnostic examination of the various mechanisms and how they're intervening in the current crisis. And thank you very much for that. So we only have about 60 seconds left, very regrettably. There's one question that's been written in, so let me see if we can get some feedback on this one. Is there any chance of elaborating a regional Asian agreement on the rights of ethnic, national, religious, etc. minorities, similarly to certain European conventions, for example, the Framework Convention on National Minorities and European Charter for Regional Minority Languages, at least in the long run, or is it totally impossible due to political realities? Any thoughts on this from any of our panelists? You have about 45 seconds to give a response. Any thoughts? Any takers? Dr. Pillai, you look like you want to try this one.
Well, I guess now I have 20 seconds left. Well, I mean, to be honest, with political realities, one of the points that I was going to make actually is that in Asia, we don't have enough multi-layered sort of regional mechanisms. We don't have, a regional court framework. We really have a strong argument around Asian exceptionalism and sovereignty and, the pushback against the ICC. So the lowest ratification in the world for the International Criminal Court is the Asia Pacific region, with 19 states and 1 withdrawal. So I think that there's a lot of this sovereignty and exceptionalism and allegations of neocolonialism, which pop up with most in Asian states and the discourse around this. So I really, looking also at ASEAN and the way it's reacted to Myanmar and the current crisis, I wouldn't be that optimistic, but that's not to say we shouldn't try. I mean, I think we need to try all legal avenues, and at some point, some of these strategies will work. So.
Thank you very much for that answer. So unfortunately, everyone, we are out of time. I want to thank all of our speakers very much for their time and their insights and their work. So thank you, Dr. Ghosh, Dr. Butt, Ms. Nu, and Dr. Pillai. Thank you very much for your expertise and for sharing your time and knowledge with us today. And we will continue through the ASIL Asia Pacific Interest Group webinar series to engage on this and related issues of international law in the region. Thank you all for joining. Take care.
Thank you very much from the audience.
Thank you.